Thank you very much. Uh, Welcome, the extension workers of the country. I believe you're all interested in knowing the whole point of why you have to be aware of the provisions of those acts which matter to your subject, the farmers of the country. And I have been given the task of dealing with two of the acts, although I would focus on the first one, the Protection of Plant Varieties and Farmers' Rights Act, and also narrate the Seed Act part, which is in brief. Because Seed Act, most of us are well aware in terms of the usage of the Act for regulating our seed quality and seed-related standards for selling farmers or selling it to the market in the existence of the notifications and truthfully labeling, etc., etc. So, which most of us are aware of. So I have not spent too much of time since in the given 1 hour, 20 minutes or so. But so Prabhu, is this interactive one? Like people will interrupt and speak, or is there going to be a discussion subsequently after the presentation? Do we have a provision for discussion?
Yeah, definitely. You can ask questions, and the participants can also react to that.
No. I mean the reverse way. If the participants want to ask any question,
Definitely,
will it be there?
definitely.
Okay.
Yes. There
So
is
then
problem.
I need to finish. I need to finish by what 11:50. What time was it? 11 o'clock was the time given to me. Right?
Yeah, it is up to 11:30, sir. You can take about 1 hour, sir. Up to 11 o'clock you can. Then 11 to 11:30 we can have question answers, if any.
Okay.
Yes.
All right. So then I will focus more on the Protection of Plant Varieties and Farmers' Rights Act. Okay. All right. As a requirement of IP, this is the first of the signs of IP which I am putting up here, the disclaimer, so that nobody misinterprets the presentation which I make in terms of legal interpretation of the Act and page. These are my views to explain the provisions, which is the verbatim transcription in terms of transcription, but not necessarily repeat of the whole sequence of the Act as it is provided, but the comprehensive translation of the same is maintained. So that's what it is. You have to use this presentation for understanding and for quoting it to claim something which you have right for claiming. You have to look at the Act and the rules as per the provisions. Okay. To start with, let me explain the rights we have in India which are related to intellectual property. Of course, the intellectual property, the term itself is very clear that it is the output of a thinking mind, but not just the thought. A thinking mind converted into an activity which can be monitored, which can be measured, which can be commercially exploited. If these things are the applications of the thought as put in a format, in a formal manner, only in that, then it becomes IP. Otherwise, it only becomes a process which is not protectable. A thought process is not protectable. An idea is not protectable. So what is to be protected is the product of the thoughts which can be commercially traded, commercially linked. So we have the Trademarks Act, we have the Patent Act, which is most commonly confused with the Act as IP Act. Patent is only one of the protection acts. Okay, like Protection of Plant Varieties is one act, only because the plants cannot be patented in India. Globally, friends, among let me complete the acts. We have the Copyright Act, which is the easiest adopted act. The Designs Act, which is purely for it's all relevant to agriculture, where tractors or farm machinery and such things, even the processing units, even those can be designed and those can be protected. Then the Geographical Indications Act. This is one of the most, say, prevalent and well-utilized acts of protection of agricultural produce in terms of plants and products in most of the countries, because that is almost ever-extending right. Whereas in the case of other acts, including PPVFR, we have a limited period, 15 years, 20 years, 30 years, maximum 30 years. Whereas in the case of geographical indications, it is a community right. It is not a right of an individual. It is always a right of a community, and it is extended lifelong till the product exists as tradable commodity. till that time, nothing from geographic indications will automatically move into public domain till the act is repealed or the act provision is revoked for that product. Till that time, it is not. So therefore, it is the permanent kind of intellectual property. And of course, we have semiconductor, which is not relevant to us. We have the protection of plant varieties, relevant to this topic today, and also very relevant to most of us who deal with plant breeding activities or horticultural activities or activities which take out new plants, maybe in the forest species, maybe in the tribally organized, say, aromatic crop species or field crops or vegetables, horticultural products, anything which is traded in terms of seed or any seeding material which can be vegetatively propagated materials. All of these are covered under this with the name of the inventor, who could be an organization, who could be an individual. That's what it is. So we have these acts in place in the country, 8 of them. The latest is the PPVFR Act as well as the Information Technology Act. And the Information Technology Act, what you can protect is the data. Okay? Data can also be protected in one of our aspects in plant varieties. We can also protect in the plant varieties the name of the variety. So that way also moves into the IT Act sector, where information in terms of the name or nomenclature of the variety is also protected. So we have these 2 protections in place in terms of the variety and the protection, and we also have the farmers' rights, which is unique. I will explain further. This act came into force only because of the commitment of the global trade system, which began in the 1994-95 when India signed the treaty as one of the founder members of the, wherein the TRIPS was agreed upon. That is the act which relates to the tradable, say, intellectual property rights. Okay, these are the ones which are required. So there's a trade-related intellectual property agreement. So when India signed it, India was bound to do something within the provided period to enact that protects either the patent or the plants. So the Patent Act was already in place in the global agreement. We also had to do something by removing plants from the patents and introducing a standalone act in order to protect the plant, because plants are either naturally existing, they can be discovered, they can be nourished, they can be managed by nurtured, say, material variation as they come naturally by evolving, by mutations, or by plant breeding activity. So the variant form of those materials can be identified with a new nomenclature. That is what is plant breeders' right. That is what is protected. So therefore, patents from only 6 countries globally, among the 186 countries which have signed this TRIPS agreement, 178 of them are implementing it. Among them, only 6 of them have plant patent as well as plant protection. There is no country which does not have plant protection, but there are countries which have both, which is patent of the plant, particular plant, not species, not particular variety in terms of the varieties trading element, but in the varieties application of something that the plant variety has uniquely from others. That's why it is patented also, and the same variety has to be protected also. So they have both systems there in those countries, or 6 of them, all developed countries. In all the other developing countries, we have only plant protection in terms of, breeders' right protection, and no other country, including Bangladesh, which was the latest among the countries which joined in getting the plant variety protection, did not have the courage, to use the term, because they were really toiling hard to bring in the farmers' rights, but they could not, because I'll explain how subsequently. Okay. Now, the point of PPVFR. Many of us who are working with plants are aware of the CBD, okay, the Biodiversity Related Convention, and the Biosafety Protocol, which came up along with the genetically modified organisms, which were developed by that time, and the WTO 1994 as a result of TRIPS, and the UPOV. UPOV existed before the 1994 came. UPOV is a French translation for protection of new plant authority, okay, in different countries, and European countries put together themselves in the EU before the EU was formed, and the European country. Therefore, UK is even now part of UPOV, even though it is not part of EU. So therefore, these countries had already developed a system for protecting the plant breeders' right. So the WTO brought in this option: either we join UPOV or enact by ourselves to protect our plants, to keep it away from the patents, but not without giving plant breeders as patent right in our legislation separately. So therefore, India was bound by this principle of having signed the agreement, and therefore it enacted in 2001. To deviate from UPOV, mostly because of one reason, that it lacks farmers' rights, which also is very important for Indian circumstances, which has majority of public in the farming community, even now, even today. So therefore, it was different from those countries where less than 3 to 4% of the public, or even less than 2% in some other countries, are actually dealing with farming. For them, it was all right to make farmer have no right on his harvested material. A farmer have no right on the produce from there without giving some kind of dakshina to the one who gave the variety. Okay, even the processed products, which is directly traceable to the plant variety used, that needs to be also to be permitted. Even that kind of restriction is there in UPOV. So it was not possible for Indian system to believe that we can straight away join UPOV as such and follow the UPOV regulation, which was not just possible, which means every time the farmer would have new seed, which is just not possible even today with the right of the farmer, that if he decided, if every farmer today decided that he will buy new seed, no such seed available to cover everybody's need as on today. We are able to cover only about 48 to 52% max of new seed replacement in all the crops. That's the kind of demand we have for new seed. That's the kind of lack of supply of new seed we have in the current commercial option. So therefore, India really had no option other than agreeing to have its own act and also bring in the element of farmers' right, because it is a sui generis. Do it on our own, and that's by using that phenomena in the agreement, we decided to have farmers' right in there and not to join UPOV. Since India had already applied for joining UPOV before the act came in force, but as in how because as you all of us know, we never dealt with IP, we never bothered about IP, so we never understood the ramifications of having joined UPOV. So we had applied for it, not really clearly understanding what it is. But after it was dawned upon that it would mean no farmer will have the right on his own saved seed, own harvested material, and also in having the freedom to sell his material to neighbor farmer, even as a barter system or just sharing material. Even that would be in trouble, which is Indian political leaders immediately realized that is not possible. So we decided not to join UPOV on this most important factor of farmers being denied. So Indian policymakers decided that we do our own act, and we are the only country, while defying the UPOV, have been able to bring in the ITPGRFA. We are the only country in the global 178 members of ITPGRFA, which is a requirement of United Nations commitment to the all member countries, have not followed as India has. India brings in our PPVFR the ITPGR related aspect of the sharing of benefit, and also the integral right of sovereign nature on the material of the country, which is well built within our act. So therefore, we are the only country which have comprehensively dealt with the entirely available provisions in the intellectual property related activities and legislations and implementation of the agreement as agreed among all the member countries. So we should take credit to it that our the legislatures, the Parliament of India, was wisest among all in terms of agreeing or complying with the requirements of all commitments which most countries have signed and yet not signing it, taking one or the other leeway in order to take it out. In fact, the ITPGRA's next board meeting is held in India, in Delhi, in May next year, and where this is one of the most important decisions they have to make about how to bring in farmers' rights in those countries and be able to deal with their being UPOM members and their being members of their own legislations with no farmers' rights. So this is something which I'm eagerly looking for because we are organizing it. Eagerly looking forward to how the globe is able to tackle this. So rest assured, among all extension workers, we feel proud that we are the only country which have the farmers' right in place, which have the ITPGRA related aspects of commitment to the United Nations in place, and the TRIPS commitment to the WTO in place, all of them in place intact. So that's the best part we must be proud of. And what does the objective of PPFRA deal with? If you take from the left side, it's to provide an effective system protection of plant varieties and rights of farmers in terms of the rights on the variety and right to claim the product of their varieties in terms of farmers and right to grow anything they want to grow, any variety they want to grow. So these are the rights the farmers will have, and the plant breeders who produce those varieties, despite giving the farmer his relaxed right for using it and for selling it also, I'll explain a little later, he has his own right in place. And that is now being understood globally, how the two can be managed without making one sink or making the other sink. Both can be afloat is what we have established. And I'm now addressing the global gathering through the web option, is telling them how we have been able to manage and how the breeders are able to make their money despite the false impression of farmers when they sell their own product will not buy from me as a breeder and therefore I will be at loss. It is not. I will explain if time is available, or maybe in interaction I can explain this. The point is to be taken that with the farmer's right, there is nothing that is going to shave off any kind of advantage the breeder would have had minus the farmer's right. I'll explain. It is very relevant in agriculture, very relevant in plant varieties to give the farmers their right. Otherwise, it is not possible for the promotion activities which any other technology can have in making the user aware of the value of the technology, aware of the worth of the technology, aware of the returns that one can get by using this technology. All of it is not possible in plant varieties till you make the farmer grow it, harvest it, and see the product of it as it comes out. So that's the point which requires the farmer to have some right. Otherwise, he cannot experiment with all of this. So this is a requirement. That is where is the problem. That is where the problem is in all African nations. Of the 58 countries in Africa, 36 are members of UPOW. Others are bound to become UPOW members, and they don't want to become. And the members who are already there as members of UPOW are also eager to bring in farmers' rights, and they are interacting with me regularly, with us regularly, in trying to find out how they can now become get out of UPOW's regulations of not having farmers' right at all, and be able to give their farmers the right, because they also have big number of farmers. All the countries where less than 2% of farmers are there, it's very fine. When there are large number of small farmers, there is small land holding farmers, it's going to be very, very tough not to give them any right. And that too where crop commodities are very diverse. You will not get like you see in prairies or such lands in Canada, US, North America, and the other plains in Brazil and other countries where you have thousands of acres of a variety or a crop grown by commercial applications of tools and such things, mechanized agricultural systems. It is not possible in India. You have mosaic within walkable, throwing distance of a particle, you see a new crop, a new variety of the same crop, mostly other crop, and that too differently timed. So it's all going to be very, very tough in small farming, small farm holders to organize this kind of right without giving them any right to make independent decisions on the product and the material they grow. So that's why we take all these four parts in our objectives, and that's how we dealt with the Act. I'll briefly touch with the Seed Act, and these one set of bullets is sufficient to make people who are buying seed, growing seed, or say multiplying the seed, or even using it as variety for their purposes in any respect, whether as a farmer or as a seed seller. the Seed Act provides, see, the Seed Act and the PPFRA Act, they are not contradictory. Neither they are cross-cutting into each other's arena. They can coexist, and there is absolutely no crisis in following the Seed Act related regulations and the PPFRA related regulations for any farmer or any other person dealing with the seeding or seed material in India. What does the Seed Act provide for? Principally, it is an act related to quality of seed and standard of seed, nothing more. Okay, and notification of the material which can have its seed quality, which can have its seed standard. That is the only feature that the Seed Act as on today deals with. There is no other regulatory requirements that comes in the way of variety-wise materials. It is just about name of the varieties being recognized for setting standard, not protecting the name, not protecting the variety. There is no claim on the ownership of the material there. In that we take care of. Rest of the things in terms of the quality of seed, the germination standard or purity standards, those are the ones which are maintained by the Seed Act. So on the protected varieties and the PPFRA, you can implement the Seed Act perfectly well without cutting into each other's arena. So the Seed Act provides principally for the Central Seed Committee, which is chaired by the Secretary of the Department of Agriculture, and it enables the central seed subcommittees. Many subcommittees can be formed, which will advise the seed committee to take the decisions. One of such committees is the one that notifies or the variety release committee. Okay, that's what is commonly known as CVRC. There is nothing like CVRC. It is Central Seed Subcommittee on Seed Standards, Release, Notification, and Cultivation. So it is that material which subcommittee there and known as CVRC that is allowed for. That is what is created by the Seed Act, which picks up a variety, identifies it as notifiable material for cultivation under certain agronomic condition in a given region of the country, which is notified by gazette notification by the Central Seed Committee. So that's what the committee is about. Then Central Seed Laboratory. As I said, the Seed Act is about the act for quality and standards. The seed laboratory has to be there. So that has to be created by that. That is official lab, which does not mean it's only one lab. There has to be one central lab or coordinating with the central lab, state government labs, all have to follow the same standard and quality. That's what it is. Then central government has to have the power to notify seed and kind of variety, which I explained to you. Kind of varieties and varieties, the difference is, for example, basmati. Basmati rice is kind of rice. Okay, and variety Pusa Basmati 1 is Pusa Basmati, is a variety of basmati. So Pusa Basmati is a variety, basmati is kind. So that's the distinction. The Seed Act can recognize both and notify the whole kind as one if necessary in any commodity. In basmati we don't have. We have only restriction of using basmati as a nomenclature when it is grown from the GI area. A GI was a hard-fought victory for the GI region in the country, but the kind comes in there where the Seed Act prevents further release of varieties or development in terms of varieties from region out of the GI region. So all the materials which are in the basmati kind have to be only released for cultivation in that region and marketed in that region as basmati. So that is why the kind comes in there. Then the Seed Act also provides for the central government to specify the minimum limits of germination in different crop species. Somewhere it is 95%, somewhere it is 99%, somewhere it is 75%. It depends on the crop system, the kind of genetic diversity it has, and its mating system, and heterogeneity that is bound to be there, even though it is to an extent, say, self-pollinated or with minimum cross-pollination, often cross-pollinated. Things of this kind will enable levels to be changed, and then then the empowerment to label to indicate that this seed conforms to this limit. This is the quality of that seed. Within this provision only, you have that the certified seed, you have the foundation seed, you have the breeder seed and nucleus seed. They come in this provision only. And regulation of sale of seed or notified kind of varieties. That is, the seed has to be packaged in a particular form. It has to carry a particular color of label to tell what is the quality of seed. and those mentions have to be there, when it was produced, where it was produced, which batch it belongs to. So it is these kind of regulations on this material to be sold as certified material. It does not mean you cannot sell any seed. The new Seed Act comes in, when it comes in, will bring in this. You cannot sell any seed, whatever the seed is, whether it is notified as a certified seed or not. You cannot sell any seed without getting registered to sell. So that is going to come with the new act. As on today's act, there is no restriction of that kind. You can truthfully label any seed you want, and you can packet it anyway and sell it. But if it is certified seed, then it has to follow certain regulations, which is given here as the requirement in the act. Then the government or the state government, central or state government, both have to establish the certification agency so that they certify the seed to a particular level, if it is foundation certified or a breeder seed. So that certification is accorded, and accordingly the variety is dealt with. Then it also grants a certificate. Obviously, once the inspection is done, certificate is issued. So that is all the Seed Act does. So these are the main provisions of the Seed Act. Others are only secondary to these provisions to implement them. Other provisions in the Act are only to implement them and give rights to the people who implement them, in terms of visiting the site or sampling, and in fact, they also have the power to confiscate seed which they think is not being the correctly labeled one, or things like that. Okay, so these are the empowerments in the Act subsequent to this. But the crux is these 9 bullets. Okay. Now, in the case of plant variety protection, coming back to the variety protection part, it is not that every variety of every species can be protected as on today. As on today, we have 165 different crop species, which cover most of the crop, more than 90% of the crop system, including the forest and horticultural products, which can be protected in the country once we notify it in the Gazette. But in the case of farmers' varieties, okay, there's an exception. In the case of farmers' varieties, no species recognition is required. There is no requirement for notification of a particular species when it comes to farmers' varieties. I will explain what is farmers' varieties so that there is no confusion. It is not that any farmer who is breeding new variety today is known as the breeder of a farmer's variety. He is known as a breeder of a variety, but not farmer's variety, if that material is not conforming to certain standards. It is only those species of those varieties which can be protected by us, even if they are not in the list of 165 species notified. Okay, I hope this part is clear. Farmers' varieties, which are known as farmers' varieties, which I'll explain now, are those which are within or outside this 165 species. Okay. The protection period itself, whether it is farmers' varieties or breeders' varieties or any other material which we protect, is protected maximum for 18 years in the case of trees and vines, and 15 years in other crops. We are the only country which has the least number of years of protection. Indian Parliament decided to keep it the least number of years of protection in order to make varieties slip into public domain after the period is over, so that it is accessible by all for further sale or further multiplication, but without having the recognition of the owner as the owner of the material, any more than just getting to him for the purity maintenance in terms of getting best seed or pure seed. That's when a competition will happen to showcase that I have an agreement with so and so as the breeder, so therefore my seed is better than the other seed who has taken it from public area. So that's the kind of advantage after public domain slippage. But then, just for the awareness, we are the only country which has 15 years. UPA has 30 years for the varieties, and for trees and vines, 35 years. So we must understand that we are within a protection. We have allowed the possibility of the variety, because most varieties, I'm a plant breeder. I know one of my varieties which were released even in 1990s are in sale today also, in demand today also. That's because the time it takes for the material to reach the farmer and for the farmers to evaluate and accept it as a replaceable variety from this existing variety which has been growing and derive benefit out of it, and then make somebody produce it, make somebody sell it, it's going to take longer time in some of the varieties. Of course, most varieties are replaced because of plant breeding activities happen, and new varieties keep replacing the old varieties by an improvement for the existing variety. So therefore, that needs to be encouraged. That's the purpose of our act, to encourage more and more plant breeders to develop more and more varieties, to make the farmers have access to more and more varieties as per his choice. So therefore, that is facilitated by making it only 15 years. And we had to undertake what is known as dust testing while explaining. It is about the distinctiveness and uniformity and stability of the material to be established by us, and that has to be done by carrying out the tests. So why plant varieties are not patented is principally because this requirement of having to generate data and do research even before you protect, by not being the breeder of the material. Okay, this is the only intellectual property protection where the protection is given by the data generated by us. Whereas in all of the patent protections or IP protections, it is prior art or information that is already existing on the say material in the globe, in the country, being used to decide whether it is novel, whether it is innovative, whether it was existing or in one form or the other form in the country before the authorities agreed to make it a patentable product. No data is generated. In our case, we generate data. So that is why it cannot be mixed with the other patentable protection rights. In the countries where protection is there in the patent form as well as protection form, the patent form is only on prior art. They don't generate any data. Just compare the claims and look at the claims available on other such products coming from the particular material. That material, either the variety or the material species, irrespective, that is patented. Okay, so therefore, what is protected after evaluating the claim by comparing it with the existing other materials is to be done only under protection of plant varieties. Right? That is simply by comparing given information is coming under patent. So only 6 countries have it, others don't have it. So we conduct the dust test in the case of a category of varieties called new varieties, which is similar to the UPOV material, which is new variety only. They don't recognize existing varieties. UPOV does not recognize existing varieties, nor traditionally maintained varieties as varieties at all. They only think it is anybody's material to be gained or claimed, or on a domain which is not under anybody's control. Whereas in India, we not only accept new varieties, we also accept varieties which are not older than 15 years, the total protection area, which is known as varieties in common knowledge, VCK. Then we have farmers varieties, which will go beyond 15 years also, which are the traditional materials, which have been conventionally maintained by the farmer or the community. And sometimes an entire community, especially in the land races, okay, Nagina, for example. Many materials, Agra local in wheat, for example, Karshia in wheat. So these are all Totapuri. These are all traditional materials, Langda. These are all traditional materials which have been grown by the farmers in communities. So the entire community is protected, is capable of claiming the protection of the variety. And once protected, they can also make the same gains from those rights as any other farmer. The entire community can gain out of it. We have made several such advantages, like Mushk Burji in case of rice. An entire community of some 800 families in Srinagar, bordering Srinagar, in the village, they now claim the ownership of that, just like the Kala Namak in the Gorakhpur that area, Gautam Buddha Nagar, and I think Siddhartha Nagar area, the GI of this material. Those entire community can claim on the right of that. So those varieties are protected by us as community rights, where they can claim entire commercialization principle like any other common variety, but the community gets it. The panchayat or the association or anything that is deciding the community base, that can be done. We also have the Seed Act base. This is another commonality between the Seed Act and PPVFR. The Seed Act based notification by the Seed Committee, Central Seed Committee, that is recognized by us as extant notified variety. So we give a separate category without dust test. No testing is done because it is following a test evaluation. We use that data generated while the variety is being notified, and based on that data, we give the claim of the breeder who bred that material. Voluntary. It is by desire, like notifications are by desire, by choice. This is also by choice. Whereas in Europe, the UPOP, there is no choice. There is a compulsory registration and a compulsory selling only after registration. So therefore, if one wants to breed a variety and sell, one has to protect it. It has to be unique. It has to have the same DUS. That means no person can sell a variety which is already existing and bred by somebody else without taking authority or power from that person, even if it is not the same variety but similar looking variety. So that's the case. They have no recognition when our act is capable of recognizing similar looking two different genotypes, that is phenocopies of two different genotypes. If the genotypic sequence is given to us and there is an expressing region, I can protect that second variety also, which is similar looking to the previous variety, provided this data is made available to us and we say generate the data and evaluate it and compare it and confirm it. If that happens, we give it. So we have that advancement within our law at the moment, whereas UPOV is still struggling in looking at molecular data to accept it for any purpose. So therefore, we have made some advancements in this by allocating the farmer his right and also introducing the latest of technologies also protectable within the provisions of the Act for the breeder to get his right subsequent. So that's what it is, by special traits. We call this special trait. Here, as an expressing region, so the express region can be anything, but similar looking, but genotypically on the different genomic region or different genomic, say, constitution in terms of the sequences. That means the translated product is different from the previous one, but it has the same expression as the previous one. So therefore, we recognize that as a new protein and therefore new expression and the new character, and therefore that can be used as protectable material. So this should be well understood by the extension workers, who at times will see two different names for similar looking varieties, which indeed can be different. They have to only evaluate it by getting into touch with the geneticists or biotechnologists and get the particular DNA of those important traits, those proteins identified, those sequences identified, and see if they are different sequences or they are in different genomic regions, that is different linkage groups. I mean, blind breeding terms it is. If those are establishable, they can be protected. Okay, so this extension worker should be aware of, not just confuse that this is the same variety with a new name. Not necessary. If there is a claim, especially when there is a claim of two communities, then you have to give credibility to it and establish first that they are not the same. If they are not the same. In the case of the trees and vines, obviously we cannot run trials because you know it. Trees come to flowering maybe in many cases 3 to 4 years after the seed germinates. So there is no possibility for it to come to full bearing to get all the expressions of the characters that makes one variety different from the other variety established and then plant them together is also not possible. So what we adopt is on-site dust testing in those cases where individual trees are also labeled, individual trees as the mother tree and the clone tree, anything of this kind are all taken up and then accordingly done. So we do dust testing there also, but different from the existing trial system, but on a same number of years are taken. We take little more period in the case of on-site testing because we get it organized and also establish that the varieties can be maintained by their vegetative propagules, which can be anything, cutting or budding or grafting or anything. All those things have to be established after the application is made. So that means its reproducibility is there, its commercial viability, because commercial viability is the basis for protection of the variety. If nobody can produce it and sell it for any reason, there is no point in protecting it. So we have to establish that the vegetative reproduction system of the tree is in place and that it works, representing the same variety without any kind of somoclonal such other variations which make the mother tree different and the multiplied tree different. If that is not there, we have to establish that. So that takes a little bit of time, maybe 2 years, in addition to the normal testing time. So this is how it is done in the case of trees and vines. Okay. Now, what are the plant breeders' right? I said the plant breeders' right and farmers' right. We deal with both. The globe deals with only this column, the last column, where you see the rights. That is the right to produce, the right to sell, to market, to distribute, to import, and to export. These are the rights which the breeders have, which means farmers have none of these rights. The farmers neither can produce the seed, they can sell the seed, they can market the seed, they can distribute or share the seed, of course, import, export. So it's just not possible, which is what is restrictive in the case of UPOM membership. We have, in addition to this, the right for the farmer. Now, the breeder also has a right, other than these rights, also has one right which is free for the plant breeders like me to take any material protected without seeking permission, because I'm neither producing it for the sake of producing it, I'm not selling it, nor importing it, exporting it, or distributing it. I'm only using it for the purpose of either creating a new variety by using it as a parent, or experimenting on some feature of the plant related to its genetics or its physiology or its adaptation principle or anything related to its multiplication, related agronomy, or anything related to it, or any product from there which has a commercial value in terms of an extract from that, whatever. If I have to do any of this such experimentation, I don't need to take permission of the original breeder of the variety, because I am not impinging on his right to produce, sell, etc., etc. So that's where the permission is given, except when it is to be used as a parent of a hybrid. Okay, if a variety has to be used as a parent of a hybrid, then the hybrid itself cannot be sold without the permission of the original breeder of the parent, because hybrid by itself has no validity to be multiplied minus the parent. So every time you produce a hybrid seed, you need the parent. So therefore, it is not for experimental purpose. It is for the commercial necessity of to having the use of parent as a essential requirement for producing the hybrid seed. So there, if it is for producing hybrid seed as a new variety which you want to produce, then you need to take permission from the original breeder of the parent. But if it is to be hybridized only to develop recombinants from the segregating generations, you don't need to take any permission from the original breeder. So that is the right of the experimenter, or this is the plant breeder's exemption. Not the plant breeder who bred the variety, but the plant breeder who would like to use this variety, another plant breeder that is, would like to use this variety to breed a new variety. Okay? So this is an exemption given in our act. This is there in UPOV also. Okay? Now, what are the plant breeders' rights which are likely to be violated, and what is the violation principle? Anybody who, other than the farmer who sells the seed as a produce of his farm, okay, other than him, if anybody who sells the material or exports it or imports it and produces the protected variety without permission, any of these activities carried out by anybody other than the farmer uses it for traditional purpose of farming and sells it, not by labeling it, not by packing it, not by naming it, then he is in right. Anybody else, if he does it, then he is impinging on the right, and that is what is the infringement of the plant breeder's right. Then they can come to me, come to the chairperson of the authority, giving evidence, and if they give the evidence, then we'll see that the case is filed in the court as required. Other than the infringement case, all other rights are dealt by the authority, either by the chairperson or by the registrar, with full powers of civil court. Okay, I have the power of civil court on the matters related to varieties within the provisions of the Act. So therefore, we have this, like my decisions, my orders, whether it is on government, including central government, or state government, or any government agency which is selling seed of the variety protected, is bound by the orders I take, and they have to only approach High Court or Supreme Court to do away with implementing my act. So it is the same kind of power like any other judge has in the district court or session court or whatever, or up to the High Court. Okay, that's the right we have, or legal right I have as a judge. We hear the cases just like any other court hearings, where senior advocates, advocates who are registered advocates, can represent a company or a farmer as a user of the variety and seek a claim as provided in the Act. So that's what it is. Then the second infringement is anybody who uses, sells, exports or imports any variety giving the denomination identical or deceptively same. Like Pusa Basmati 1 is registered with us. Somebody may write Pusa Basmati 1 or Pusa Basmati 2, something like that. If they want to name it like that, then they're infringing on my right. And if they sell another variety by the name Pusa Basmati 1, which is not actually Pusa Basmati 1, then also he is infringing. So these are the acts which amount to infringement of the rights of the breeder. And of course, the penalties are there in plenty. Okay, they are not, of course, they are bailable penalties, not they're non-bailable. They're all bailable offenses, and it's required for us to train the district, say magistrates or the district commissioners, police departments to undertake these FIRs, to recognize these claims, these complaints of either the infringement related claim by the company which is breeding, or that the right of the farmer is not in term of the material which is given or sold by the company as a variety. All of these applications, FIRs had to be recognized by them. Some of them ideal, some of them has to be dealt by the other systems such as the normal court. Okay, like the Pepsi potato case, which was the infringement. The Pepsi's rights were apparently infringed by a group of farmers in Gujarat, and the Gujarat court in Ahmedabad decided that the farmer's claim is wrong and the company's claim is right, and they put up a ban on the sale of the potato, Pepsi potato, of that particular variety, which was protected with us. So that is infringement, which the court will deal. So such things are all provided for, and up to 5 lakh rupee and 1 year imprisonment can be ordered by us for the one who violates the act. Okay? And there are a lot of principles to be used for granting that, like the court granted more than 1 crore 10 lakh rupees per farmer to be paid to the company for having infringed the right. So this kind of options are done by looking at the option the breeder has, he claims. Then the damages as claimed by him are evaluated by the adjudicating authority, and the share in profit which has been denied by somebody else infringing on it is to be taken as a loss that has been caused to the company or the breeder, and therefore that has to be compensated in terms of determining the relief. So that is what is done. Okay. I'm sorry. Yeah. Why the same files are coming? Okay. Now, farmers' rights. These are different from the plant breeder's rights. Unlike the breeder, the farmer is entitled to save the protected variety also, to use the protected variety, to sow the protected variety, to re-sow the protected variety. That means has his own product which is saved and then use it for sowing the next year, to exchange, to share, and to sell. Here the extension workers have to convince the farmers. Okay, this is my request to the extension workers. Although he has a right to re-sow, you must ensure that re-sowing does not happen repeatedly more than once, because the quality deteriorates. Although he cannot say name it, he cannot brand it and sell it, the name is in the air, and the variety which is protected by the breeder, because of this lack of purity at the farmer's end, because he has no idea about maintaining the purity, the cross-pollination that may be in the species, and the varietal heterogeneity because of this existing, which is not able to maintain, he is not able to isolate. Those things are not happening with him, and because of which, and even the maintenance system or the seed may not be good enough, because of which the viability may be lost, the germination potential may be reduced, the variety's name gets spoiled. Because farmers will say, oh, this variety, ये तो ठीक नहीं आ रही है, इसकी stand नहीं ठीक आती, इसमें अलग-अलग किस्म के पौधे आते हैं. These features will come up in the farmers, say, cross exchange of words, the mouth-to-mouth, year-to-year, or mouth-to-ear spread of information, informal, but spoils the name of the variety. So therefore, let the farmers not multiply it on their own, save their own seed for more than one season in order to maintain the value of the variety for themselves. See, their product also will be deteriorated. Their value of product also will be reduced. So therefore, it is not of value to them if they have this right and want to use it with impunity. Let them use it for once, not more than once. Up to 1 year, the deterioration is not so much. Beyond 1 year, sourcing that seed from the second year, third year, fourth year, there will be deterioration in quality, deterioration in genetic integrity of the material, but the name remains and the variety gets spoiled. So that is not good. So that should be prevented. So I request the extension workers listening to me here to make this point clear to them that this is for the good of the farmers only, that they buy new seed as much as possible, as many times as possible, as many number of years as possible. And the cost invested in the seed is the least cost. The cost they would have invested in saving that seed, protecting it from moisture, protecting it from the insects, pests, diseases, while in storage, and then seeing that it is say properly harvested, that additional money they put in doing this, like keeping it in a system with extra protection of moisture, all those things are more expensive than buying new seed. This should be made aware to the farmer. So these are the rights the farmer has to exchange, to share, to sell, minus the point of selling it without branding. What is farmer's variety? This should be well understood by all of you. Please understand this very, very correctly. Farmer's variety is only those which is traditional variety. It is not that variety which he has taken from the university, variety released by Dr. Ramesh Chand, that he wants to now grow it. He has the right to grow, right to sow. He has the right to sow. But that is not the right of farmer's variety. If he takes out something from there and comes to me to protect it as farmer's variety, it will not be farmer's variety because it is not traditional variety. It is an improved variety. So the extension workers have to convince the panchayat systems which have to forward those applications, that make sure that while you forward the application of the farmer for protection of his right as farmer's variety right, you must make sure that that is not a variety real which is purchased from the market, purchased from the university, or brought it from the university or breeding company or any other resource as a material which was not traditional to him. So this should be well assured, okay? Then of course, the second material which is farmer's variety is the wild relative or the land race of the variety of a crop species, which the farmers have been maintaining very close to their heart, close to the community as their right. So these are the only two material category which distinguish the variety as a farmer's variety. Once it is a farmer's variety, they get extreme benefits of not having to pay any fee to us for the protection of the right. Okay? And also not to claim a novelty related requirement. There is this 15 years, or it has not been in sale for more than 1 year, or not in exploitation period as a parent of a hybrid, or anything, which the new variety breeder has to put in when he applies. Those are not applicable to farmers. And therefore, the farmer's variety advantage cannot be given to non-farmer varieties, which are non-traditional varieties. So this, if you want any clarification on this, please ask me. And we have put up on our website the FAQ in Hindi and English, which you can clearly see. Question number, I think 12 to 28 are those which are dealing with all the farmers' right related questions. Feel free to go through them, and also feel free to ask me anything you want to ask on this material. Okay. Am I going too slow? I think so. Okay. Now the extant varieties. We have extant variety, as I said, not only new varieties. Extant varieties are those varieties which are in market for no more than 1 year. Okay. Released before they come for application of the variety, but not in trade or not in use as material for new variety development, or materials have been developed by using that as a parent by others. If these things are not there for more than 1 year before they come for application, then it is a new variety. Anything other than this is extant variety. So that's it. Now, which are the varieties that qualify for registration? Farmers variety or community. As I explained to you already, the varieties are traditionally cultivated, varieties which are wild relatives, the land race about which the farmers possess common knowledge, and the use of traditional varieties or land races maintained by the community or village, or selection from those are all traditional varieties. Okay, these are the farmers varieties. Selection from traditional varieties, which will be new, not very old, but essentially having the features of the traditional variety with a new trait or new variability. That is also farmers variety. Okay, and in the case of vegetably propagated species, there's an exception in our case. While application of the other materials requires seed submission with the application, for the sake of vegetatively propagated materials, we have set up different centers in different places in the country where the material has to reach. The live material, which is the seedling or sapling or graft or a bud, whatever, they have to cutting. They all have to go to those restricted places which we are notified in different crop species, which have now come to registration. As in when among the 165 species, anything comes to registration to us, or either forestry or whatever, we will accordingly set up the places where we maintain a permanent nursery, permanent, say, reference variety collection center as a live germplasm or genetic stock bank. And there we can set up as the application comes in. So extension workers need not limit themselves to only these 5 species. That only these 5 species of vegetably propagated that can protect, farmers can protect. It is not so. They can protect any other materials. They only have to come to us, and when they come to us, establish. This investment is required, unnecessary investment if there is no material to protect. So we'll protect without any hesitation, immediately without losing time, if such an application comes in. Okay. And what are the enclosures that you have to give? They have to fill certain forms. They have to fill certain questionnaires, which is asked, and they have to give some application, some format which they have to fill if somebody else is applying on the behalf of the farmer or behalf of the variety breeder or anybody. So that is on a PV1. And PV2 is somebody who needs to be contacted, who needs to be assigned the right to deal with the application when we question them for something or ask for some details, and they have to declare that it does not carry any transgenic product, it does not carry any genetic use restriction technology, and if it is a transgenic product, it has the clearance of the Environment Ministry or GEAC for using it for development of varieties. And the fee and seed, which is that is, fee has to be paid and the seed also has to be given, which is according to crop species, according to the test that has to be conducted. There are 2 different kinds of fee. One is the testing fee, another is the application protection fee. Application protection fee is not returned, whereas dust testing fee is returned if we don't accept the material for testing further. And of course, these are all the normal routine where we give acknowledgement after we receive the application. And see, this is important for the people who are dealing with the farmers or dealing with other seed companies in form of extension, that we accept the seed to be tested in a given year if in that year, in the window given, such as for Kharif crop, 1st March to 15th April. If the seed is submitted, application is submitted after 15th April, the testing will happen next year. We'll accept the application, but the testing will happen next year. So therefore, it is very important that they come to us in the given window itself, not beyond the window if they want the testing done in the same year. Well, we'll accept the application, but the point is to be understood that the testing will take time. But then they should also be informed that if they believe that they have a reason to, if they have a reason to deal with the companies or other competing breeders who are likely to sell their variety or multiply their variety, then they can come to us even out of the window. As long as they get a provisional protection. Even before protection happens, during the period of this application processing, if somebody infringes, which they don't want, if the breeder does not want, then he can claim that infringement, but after the protection registration is given by us. While the period is valid, but the claim will be valid only after we give the registration. But that feature will be available. Therefore, they are encouraged to come to us to apply, but the testing will take 1 more year. That's the only thing. Okay. Like Rabi crops, 1st August, 15 September. Summer, it is 1st November to 15 December. So this is the time of the application when the testing will be assured done in the year when the application is made with the material. Okay? And there, of course, there are certain ranges of what constitutes the varieties acceptable as uniform. I don't have to go through the detail because they are all varying from species to species. But on an average, example is in the case of tomato, out of 75 plants randomly picked up, if 2 plants show variation, we accept. More than 2, we don't accept. In the case of farmers tomato variety, it is 4 out of 75. That's the number of types we can accept as representing the uniformity of the variety. Minus above that, we will not accept it. Okay. Then we also have this journal called Plant Variety Journal of India. Sorry, friends. We have this journal which is equivalent to a gazette. So anything that comes out in this is a legal statement, is a legal documentation. So this can be referred by any legal courts for taking their claims further. So that is what is important for us. This is a requirement. I request Dr. Ramesh Chand and other vice chancellors or institution managers to please recognize this. I have already issued this notice to all the institutions and organizations that you have to have a feature that enables the farmer's variety when the farmer comes to you to accept the application. Do not reject the farmer, return the farmer on any pretext if you know that the farmer is genuine and the variety that he has come up with, the crop species which has come up with to you for getting it verified, forwarded for say registration purposes as his variety. Do not return the farmer saying any reason that we don't deal with the material, we don't deal with this crop, we don't have the breeders who recognize this. Don't have any of it. Immediately contact us. Give your problem, if you have any problem, by referring to the material being made available to you. Then we'll facilitate everything else as required so that the farmer is not denied his right and given all the encouragement to see that his material is evaluated properly. And if it is indeed unique, India is different, give the right to him, and that you have to facilitate. So there's a legal compulsion on any vice chancellor of or any ICR institution or any agricultural commodity based institution of CSAR or ICAR or anything in the country, or forest or aromatic, medicinal, any group of plant species, tribal forest plant species, any of them. If they come to any of these organizations, they have to encourage those farmers, and we will provide the facility, including the funding, expertise of technical nature as required by them, or anything, including hiring land. Why I want you to understand this is, you will require to carry out one season experiment with those materials. There will not be trees. Trees will be in the farmer's field only. In the seeded materials, you will have to grow the crop either in your own campus or in the farmer's campus only as required. And there we will provide them all the facilities, provide the institution all the facilities they don't have, including they want to travel, they want to engage a field staff, whatever, so that you establish that the material is unique. Material is uniform genetically, because farmers' materials, I found most of the material, 95% of the material claimed by the farmers lack the uniformity for it to qualify. That is unfortunate. You cannot blame the farmer because, as I said, they have no idea about the uniformity, and land races are mixture of inbred lines most of the time. So what actually makes the land race, only community knows. So you go to the community, grow the crop there only, and make the community tell you what is representing the variety, remove the other plants, then bulk the seed, then come back to us with the protection that you facilitate. That is legally facilitated. Your signature is valid. The signature is most valid, most valuable for us to accept the farmer's variety, and you will get the recognition for having facilitated it. And there are other features by which you can, the breeder involved in this can take benefit for having facilitated this in the public interest. So these are all already issued by us as notification, which is valid as a court order. Then comes the point of benefit sharing. The benefit sharing is something that is available to any breeder as well as the farmer. Okay, breeder has to claim after we put up in the plant journal that so and so applicant has come forward with so and so variety as his claim, and this has these features. You just see if this is already existing in your region or if it is your variety. In the case of breeder, then within the 6 months of publication, they can come to us and apply that this material is mine. This character was not there in germplasm of the species. I created it and they have used it. So I need a benefit for having made that variety get a value because of my character. So we decide based on the genomic constitution, based on the application value, and then determine the amount that needs to be shared by the breeder after commercialization, like 5%, 1%, 2%. We will decide based on the extent the trait has given value. In the case of farmers, they can come anytime during the 15-year protection of the period as a community right. The community can claim this was our variety, the breeder has got this used without telling us, or the major character from this is our character, which they have used in the variety, we need this benefit. So they can come to us anytime during 15 years. Plant breeders can come within 6 months, whereas the farmers can come within the 15 years or 18 years of protection. So that's the kind of benefit the farmer has. And this is what is the right of community. Now, can the farmer or a community directly come for registration of farmer's variety? No. The extension workers have to clearly explain to the farmers when they reach their sites and when they come to know that this variety is unique and the farmer wants to protect it, then please tell him to contact first the panchayat leader, then the panchayat leader contacts the university or ICR setup or any other formal research setup to see that this verification of the purity and uniformity is made by the breeder or by the breeder we employ on behalf of the institution, which we provide expert from anywhere in the country, and then that is protected, and that is only then it is applied. So therefore applications cannot be directly made by the farmer with us. It has to be through a formal certification verification of the material. Okay. Then this is another unique advantage of compensation right the farmer has. If the farmer claims that the variety which he bought is protected by us, and the breeder sold it, saying that agronomically this is the breeding, this is the total productivity of this material on an average by following package of practices, which you will have referred to, not necessarily giving all practices, but will say as per the state package of practices or as per the say central practices or as per the practice given here. Whatever he can publish in the seed packet, and if farmer has followed it and has not gained the productivity, then he can claim compensation and we will award it. If we evaluate, I will not evaluate it, various means of evaluating it. Once evaluated, then once decide that the farmer has to be compensated, then I use the power of revenue recovery. That means I simply order the district commissioner, this farmer in your district will be compensated with this amount of money, 5 lakh rupees by so and so seed company in your area. The seed company is a seed selling agent is in your area. He is the seed breeder, a variety breeder, a variety seller, a variety right holder, whatever the right holding is. Now you confiscate his property, auction it, and from the proceeding, give 5 lakh rupees to him, to the farmer, and rest proceeding, give it to us as a gene bank, a gene fund of the government of India. So this is what is the power we have and it can happen during the Institute of Agricultural Sciences. If a farmer uses one of the Malvi varieties of your crop, follows all the package of practices of a protected variety, and he does not get the productivity, and if I am convinced that the farmer has used everything as it's done and the variety has failed because of its inherent genetic instability or seed quality, then I will award against the Institute of Agricultural Sciences of BHU certain amount. And if the university does not provide, I will have to use the power of revenue recovery by talking to the district commissioner of Banaras and ordering him to do certain procedures. So this is what is the power a farmer has in claiming for compensation in case he establishes. It is not easy to establish, that's the fact. But once he establishes that he has used everything as should be done, and yet he has not got the product, then he will be entitled for that compensation. That is what is provided. I think I'll stop here. It's beyond my time. I would like to make you ask questions if you have any questions. Or if there is time on other days, maybe Monday or some other day, they can feel free for another specific people can be put together, Prabhu, if you want, and I can have more discussion, intent with focused questions if they have. Okay, I think I'll stop.
Yes. Now it is open for discussion. So participants, if you have any questions, you can please put before the chairman, sir, and you can get clarifications from Professor Prabhu, sir.
Okay, it doesn't matter.
Sir, yes, sir. Sir, very nice session, sir. Thank you very much. In fact, we never get tired to listen to you on plant protection and Farmers' Varieties Act, sir. Sir, this one doubt I just got at the very beginning when you started your session on the geographical indications, sir. The geographical indications are for the community and they remain for most of the time, sir. You mentioned
All the time.
Yes, sir. But I was just curious to know, sir, maybe with the time whether the geographical indicators will lose some of its unique traits. In that case, also the geographical indicators stay with that kind of variety, sir, or maybe a product, something like that, sir.
It is not likely to happen because the very first point of GA claim requires it to be historically on a reputation of having had this quality character. Okay, that means already evolved and evolution supported documentation is made available about the variety. So the change of that as a result of mutation or as a result of any other package of practices or a global change of climate also is less likely to happen because it has already withstood all those ramifications. All right. So therefore, it is not likely to happen. And if it happens, the community is the authority which grants the GI is in empowerment to ask the community if they are still able to show that quality character as reputation has been built on the material. If the community does not come forward with the samples which maintain it, then the authority is in fully empowered condition to revoke that protection. Okay, so it is less likely to happen.
Sir, just out of curiosity again, sir, on the remuneration part for the farmers' rights for certain unique races or some certain varieties, whether PPVFR is documenting any such antecedent factors, sir, like what will make them earn their remuneration by means of resorting to such kind of protections?
See, it should be well understood that while it is a socialistic option of encouraging the protection-related fallout, what is important is to recognize that this is a legal authority. We only give out orders. Implementation is by agencies, including the subject matter or those who deal with the subject matter, to see that value is maintained. Which means if the state governments want to take care of the farmers or extension workers want to take care of the farmers, for protected variety, if somebody else is selling it or somebody else is using the same name on another material, they have to take the first step of informing the farmers, the one who has registered the material, and make them apply by giving them logistic support or literacy related support system for making them make a claim, helping them make a claim. That has to happen. We will not be able to do it because we are the ones who adjudicate if such claims come. So we cannot be sitting on both sides. Is it not? So we do not. But we do get information such as the very popular one is the Mushk Burji, or in the case of rice again, one of the varieties, Vishnu Bhog or something, from the Chhattisgarh area. Okay, where the entire community has now raised the sale value of their variety seed by more than 200% from the existing variety before registration, because now the community is governing that the sale is only from there, and the state government is supporting with the involvement of the extension of the university, not JNKV, the other university in Chhattisgarh. So they are Raipur University.
IGK Raipur space.
Yeah. So they are doing it. Because of that, of course, we facilitated in the beginning by making them grow the material and have their field gene bank, so that there's no confusion in the seed variety. And also took a commitment from the university that they will give the nucleus seed to the community so that purity is maintained. And therefore, anybody else is monitored by the state government who sells that variety by that name, and that brought to the community, and the community decides the material is good enough, and they take a compensation from there, or say arrangement to give some proportion of the sale. And in terms of profit, now it has crossed 12 crores. This year it has crossed 12 crores, the business from there, and the community. Now entire village is seed multiplying and selling it globally. Mushk Burji, one of the one of the bold-grained, short-grained aromatic rices of aromatic nature. So that's what. So there are cases of this kind where we are able to help farmers gain profit of large kind on industrial sector level.
Yes, sir. We have one question from Mr. Shishir Ranjan. Actually, sir, we muted every participant, so that is why many of them are unable to ask question. But now I'm unmuting one by one. Shishir Ranjan is a budding entrepreneur, sir, and he's a very innovative digital agricultural entrepreneur that we can say. Now I request Shishir Ranjan ji to ask questions.
Yeah.
Thank you, Dr. Jilli, and good morning. Good morning, Dr. Prabhu. So I represent Farmisto, and Farmisto is a startup which is working towards inclusive access of agricultural technology. And I take pride in telling myself that I am have been in agricultural extension for the last 25 years, and across the country I have worked. So, and I remember the GATT agreement when we were still student, and how the Cargill Seeds office in Bangalore were ransacked because of that legal right to produce and store and keep and sell and share and distribute. So that happened. But yes, as an extension worker, I beg to differ on a small note on what you said, that we must prevent the farmer from growing it for the second and third generation. You see, I feel, and I'm really sorry to beg to differ on you on this count, that I feel as an extension worker, our role is to educate the farmers and pros and cons of the use of fresh seeds, on the use of good quality seeds. But to do the policing, that okay, you don't grow seeds and don't grow seeds, all the farmers are aware of the importance of new seeds and the cost. And even every company who is selling their seeds, or breeder who is selling their seeds, they also educate why they should buy it from them rather than reusing, because of all the heterogeneity and all those things you told. So that is the only one point on which I really beg to differ, and I was not able to understand the rationale why I should, as an extension worker, prevent the farmers from growing more than one seeds. They, as a customer, they have the right, and they know the right, and they have the right to decide whether they want to grow, take high yield or different yield, or I don't know. So I think I made my points. Thank you. Thank you very much.
Good. See, the extension worker is not only dealing with the farmer. Extension worker is also dealing with the technology producer.
Right.
Extension is a link between both producer of the technology. He could be farmer also, he could be breeder also in this case, and the farmer who is a user farmer. Okay, you have to deal with both these people. Both can be farmers, both can be farmer and breeder. Now, the point why I requested that is, as a requirement, legal requirement in the preamble of the Act itself, this is the Parliament decided to see that the farmer is given access to new varieties, all right, but the varieties are made available to the farmers by breeders. Okay, which means breeders' varieties have to be with the reputation of the variety as distinct as the material that is going to give them money. If the purity related value point of a variety causes the variety to get a bad name, which I've experienced myself as a plant breeder. We sold one of our varieties PRS10. We gave license. I started it as a licensing system in the public sector, licensed to about 42 companies, and forced them to call it by the same name, PRS10. Okay, Pusa rice hybrid 10, without realizing that 5 companies which invest big money to produce a hybrid in the purest farm, and 15 other companies or 25 other companies don't invest at all, don't invest a breeder. So they have everything, A into R mix up. So many things happened, but the variety is sold in different packets by different companies with the same name. In most cases, the variety's purity is lost. Variety got lost. It's such a fantastic variety even today. Okay, but it lost because of this. So variety got killed because of this lack of maintenance of the purity. The name became bad. It is highly variant. इसमें बहुत mixture आता है. अच्छा नहीं है इसमें. बीमारी आ जाती है. कुछ variety, कुछ plant में बीमारी आती है, कुछ में नहीं आती है. इसलिए उसका कोई value नहीं है. सारा seed खराब हो जाता है. इस तरह का जो आपस में बातचीत होने लगी किसानों में, तो फिर किसानों ने उसको लेना छोड़ दिया. तो ये जो प्रॉब्लम है वो किसानों को ही भुगतना पड़ेगा ना. इसके लिए तो वो जो वैरायटी का मर्डर होने से अच्छा किसान भी उसको बेच नहीं पाएगा अगले किसी को, तो वैरायटी उस किसान के लिए भी खत्म हो गई. तो ये प्रिवेंट करने के लिए मैं कह रहा था.
I fully agree on that point, those points, and that is why all the companies, and I worked with pioneer of hybrid companies, starting with Hybrid Rice International, which is now a part of Bayer Crop Science, and you promoted many hybrids in Northeast and Orissa and other places. So it happens, sir. But yes, that is why all the companies keep their patents, keep their breeders and all those nucleus seeds intact, so that does not get mixed up and that does not get the quality is not lost over generations. फार्मर्स के खेत में जाएगा तो वो तो ब्रीडिंग, इनब्रीडिंग, क्रॉस ब्रीडिंग वो सब होगा और प्यूरिटी लॉस होगा ही होगा. So that is the challenge of the breeder to keep the purity intact.
Yeah.
शिशिर जी,
I agree, but वही है. देखिए, legally speaking also,
Yes, sorry, we are taking the time on next speaker.
नहीं कोई बात नहीं. नहीं, एक्ट का प्रोविजन भी फार्मर्स राइट में रीसो है.
Right.
Not repeatedly so. It is only रीसो. ठीक है ना?
I don't know, sir. वो जनरेशन
एक्चुअली मैं इसका जेनेसिस में बता रहा हूँ. नहीं, रीसो का जो यूफॉर्म में जो शुरू हुआ, रीसो हमने क्यों डाला हमारे इसमें? रीसो का वजह क्या थी? सीड अपने डाल दिया, नवंबर में सोइंग करनी है, नवंबर फर्स्ट वीक आपने डाल दिया, किसी भी वजह से पानी नहीं मिल पाया, जो आपने डाला था वो काम नहीं किया या काम किया ढंग से नहीं किया, तो उसको दोबारा शो करने का फिर वो था उसमें. तो दोबारा जब शो करेंगे फिर उसको आपको बताना पड़ेगा ब्रीडर को कि आपने दोबारा लगाया, क्योंकि जो लिया है वो पैकेट सेव नहीं करना उसने, है ना. एक बार शो करने में सेव नहीं करना है, वो वहां प्रॉब्लम्स है. तो यहाँ पे हमने उसको ये किया कि हार्वेस्ट जो करते हो उसको आप रीसो करो एक बार, उसके बाद.
I don't know, in India तो policing is not possible and extension workers should not get into that also. Otherwise किसान छोड़ेंगे नहीं उसको.
They should नहीं, देखो नॉलेज शेयर करना, नॉलेज को एक्सटेंड करना एक्सटेंशन वर्कर का मेजर काम है.
Right, correct, agreed.
नहीं कराना, है ना.
Agreed.
तो उस पॉइंट ऑफ व्यू से बोलता.
Thank you, sir. Thank you very much.
Sir, there is a question in the chat that one Prashant Anandji has asked that, sir, what are the procedures that a farmer will have to go to prove that the seed provided by the breeder to farmer that has underperformed?
What are the procedures? No, there is no procedures. He only has to apply to relevant government police station में या जो तालुक ऑफिस में या पंचायत में कहीं पर भी वो क्लेम अपना सबमिट करे and वहां से it will come to us.
Okay.
ठीक है ना?
Okay.
To the state government system machinery it will come to us. Then अगर वो ड्यूरेशन में ही है, क्रॉपिंग ड्यूरेशन में ही है, जैसे अभी क्रॉप पूरा ग्रो हार्वेस्ट नहीं हुआ है, तब हम इमीडिएटली टीम बना करके वहां भेज देंगे टू इंस्पेक्ट व्हाट इज देयर. उसमें काफी चीजें हम ये जो अथॉरिटी का चेयरपर्सन होता है वो प्लान बिल्डर होता है. He will not be an IAS officer or bureaucrat or any other.
Yes.
तो इसीलिए इनको रखा है क्योंकि ये पावर सिर्फ चेयरपर्सन को है, रजिस्ट्रार्स वगैरह को नहीं है ये पर्सन. तो ये मुझे डिसाइड करना है कि एज ए बिल्डिंग प्रिंसिपल जो मटेरियल उसने लगाया वो सही था, एक तो. दूसरा जो उसके एज एग्रोनॉमिक प्रिंसिपल रिक्वायर्ड उसने जो फॉलो करना था वो किया है. बीमारियां या अदर रिलेटेड प्रॉब्लम जो सोइंग करते वक्त नहीं थी बाद में आई वो हुआ क्या, ये सभी मुझे एस्टेब्लिश करना है. देन डिसाइड करना है वो ब्रीडर का फॉल्ट है या एनवायरनमेंट का प्रॉब्लम है जो किसान के कंट्रोल में भी नहीं, ब्रीडर के कंट्रोल में भी नहीं, या सिर्फ ब्रीडर का ही प्रॉब्लम था, किसान ने सब कुछ सही किया था. वो देखने के बहुत तरीके हैं. एप्लीकेशन आए भी हैं, हमने डिसाइड भी किया है कंपनसेशन देना कि नहीं देना, कितना देना है वो भी किया है. एंड दैट इज हैपेंड. वो तो कोई बहुत बड़ी प्रॉब्लम नहीं है लेकिन बहुत सीरियस प्रॉब्लम है. एंड इट कैन नॉट बी डन बाय लुकिंग एट पेपर्स, इट हैज टू बी डन बाय लुकिंग एट मेनी अदर फैक्टर्स which we take care.
Yes, sir. Sir, I think with this we can conclude this session. So really, sir, on behalf of Institute of Agricultural Sciences as well as Manage Hyderabad, so we extend you sincere thanks for sparing more than 2 hours of time, valuable time, wherein you made us aware about the provisions of the PPVFR as well as the Seed Act. There are a number of issues. I know even maybe the participant might be having number of issues, and sir has voluntarily said that he is ready to engage another session if you have any specific questions. Sir, if I get that, definitely I will be again getting back to you for having another session. So with this, again, I extend my sincere thanks to you, my profound thanks to you for sparing your valuable time. Thank you, sir. Thank you once again. Sir, namaskar.
Bye-bye.